Not surprisingly, the focus on the Supreme Court has been on the overturning of Roe versus Wade, a stunning decision with momentous consequences. So that's very understandable. But there have been some other important decisions I want to focus on in today's podcast as well. I'll also be talking about Roe. But I want to begin by talking about the new decision, Kennedy versus Bremerton, in which a coach, Joe Kennedy, had been disciplined by the school, this is Bremerton, for praying on the field. Now, he wasn't leading a prayer. He wasn't calling the fans down. He wasn't even assembling the whole team. He was just doing it by himself. But the school decided we can't allow that because it's going to be seen as if we, the school, endorse a particular type of religious expression. So the school, in a sense, was sort of reading the Constitution on its own and saying there's a no establishment clause in the Constitution. This no establishment clause appears to create a wall between church and state. We, being a public school, are part of the state, and so we can't endorse any particular religious view. It's not even clear that the school was, quote, anti-religious. The school just thought that it couldn't violate the Constitution in this way. And so this goes before the Supreme Court. Now let's remember that in the First Amendment, putting aside for a moment the free speech clause, there are two clauses that deal with religion, and they appear to conflict with each other, but they really don't. The reason they don't is because, the reason they appear to conflict with each other is because we have a wrong reading of one of the two clauses. And so that puts it in tension with the other one. The first clause is that we are allowed free expression of religion. That cannot be curtailed. It cannot be blocked by any law or by Congress. The other is that Congress cannot pass any law respecting an establishment of religion. That's the phrasing, respecting an establishment of religion. Now notice that that's really quite different from separation of church and state. Here's an article, I think this is CNN. The decision lowers the bar between church and state. First of all, there's no bar between church and state. There's this whole idea of a wall between church and state is a fiction. The no establishment clause means exactly what it says. The state cannot establish in the sense of consecrate. Well, I mean, we don't need esoteric readings of words here. There are countries that have established religions. England is one of them. They have an established Anglican church. And so the state endorses certain religious ceremonies while, of course, affording tolerance to others. We had in this country, in the early days of the Republic, states that had established religions. The Anglican religion over here, the Presbyterians over there, the Congregationalists over here, and so on. So this was religious establishment. By the way, notice the Constitution doesn't say states can't do it, it says Congress can't do it. But the meaning of establishment is really clear. And so what happens here is that Gorsuch writes an opinion basically saying, listen, when we look at what this coach is doing, there is no issue of religious establishment because the coach is not acting on behalf of the school. This is not the school taking sides. This is the coach taking sides. And what is the coach taking sides with? What is he, in a sense, engaged in? Well, he's engaged in, obviously, a expression of his own religious beliefs. And this brings us to the other clause in the Constitution, which is, of course, the free expression, the freedom of conscience, the ability for him to exercise his religious beliefs as he sees fit. In other words, what the court is really doing is applying a certain measure of contextual reading of the situation. And that is, in context, the coach is doing nothing more than expressing himself in a religious way. And kind of what the court is saying is, listen, these religious expressions cannot be curtailed any different than any other kind of expression. So let's say, for example, the coach said something like, I am against racism. And he says that on the field. Again, he's not leading the audience in a chant. He's not even leading his team in a chant. He's expressing himself. Well, the school wouldn't discipline him for doing that. And so the point here is that why are we singling out religious expression as if it is something particularly dangerous about it? Well, from the point of view of the left, they do think it's dangerous. They do think it violates this wall of separation. So, interestingly, the real wall of separation is not between church and state. It's really between the left and the right in this country now in their understanding of the Constitution itself. Here is Sotomayor in a very, let's call it, unself-conscious passage where she basically says something like, the coach's action is making the school into a purveyor of religious indoctrination. And in effect, she says, somewhat comically, the school should really not be in the indoctrination business. And any of us who have been following these schools with their gender insanity, with their racial indoctrination, critical race theory, all the rest of it, pride this and pride that, know that schools have become engines of indoctrination. And so this pious claim, schools have got to be free of indoctrination coming from Sotomayor, doesn't really persuade at this point.